I'd squail, everyone. Welcome back. We hope that you had a lot of nourishment over the lunch hour. I was going to introduce Dr. Darcy Lindberg first. He decided to make his grand entrance down the stairway as I do so. He is Neheyau Plains Cree from Wetaskiwin, with his relations coming from Samson Cree Nation in Alberta. Yeah? No, I can still go ahead? Okay. And the Battleford area in Saskatchewan. He is currently an assistant professor with the University of Victoria's Faculty of Law and primarily works within the joint degree program that engages with Indigenous legal traditions alongside Canadian state law. Dr. Lindberg's research and academic work specifically focuses on Neheyau law, ecological governance that flow from the Neheyau law, treaty making, as well as Neheyau constitutionalism and how it interacts with Canadian constitutional law. He teaches courses on constitutional law, Indigenous legal traditions, treaties, and Indigenous environmental legal orders. Sorry about that. Also on the panel with Dr. Lindberg this afternoon is Dr. Carwyn Jones. Dr. Carwyn Jones is a Maori legal scholar from the Ngāti Kahungunu people. He holds a PhD from the University of Victoria and is the lead academic in the Maori Laws and Philosophy program at Te Wānanga o Rokawa, a Maori tertiary education institute located in Ota, north of Wellington. Sorry, there was a lot of Maori language there that I was trying to get through. Carwyn is also an honorary adjunct professor in the School of Maori Studies at Victoria University of Wellington and a fellow of the Royal Society of New Zealand. He is a former president of the Maori Law Society and has also served as a negotiator and in governance roles for his own community. He is the author of numerous publications, and we're so grateful that sort of the timing arrived. He was already in Canada, so it didn't take us much to convince him to just travel a few more provinces over to join us for this symposium this week. Our lovely host, Heidi Stark, is going to facilitate their discussion this afternoon that will really focus on an ethics of care in legal education or law. Please join me in welcoming them.
Thank you, Sarah, for introducing these amazing panelists, and I'm really looking forward to getting to drill them with all the difficult questions. So I thought we could start with maybe each of you, if there's anything else you want to add to introduce yourself. But if you could also then really speak to the work that you're each doing within your own Indigenous legal orders.
O tina koutou katoa, ngā mihi ki o koutou, e hui hui nei tēnei ahi, ka tautoko au ngā mihi kua mihia I tēnei ata. So greetings everyone, and I just wanted to support the acknowledgements that have been made previously to people, place, and to organisers of this event. So as you've heard, my name's Carwyn Jones. I'm from an iwi called Ngāti Kahungunu. And my river is Te Wairoa Hōpupu Honengenenga Mātangi Rau, and my mountain is Whakapūnake, and we often talk about too our waka, or the canoe that our people arrived in, which is named Takitimu for my iwi. So I work at Te Wānanga o Rokawa. It's a Maori, like a Maori university essentially. It's been operating for about just over 40 years, and it grew out of it's very much located in its place and the people there. I'm actually from outside of that group, but I'm part of the teaching staff there, and all of the programs that the Wānanga offers are grounded in Maori knowledge. So I teach into a Maori Laws and Philosophy program there, which we explore Maori law in the context of the kind of broader worldview and philosophy of the Maori world. And that's really our focus, so we try and centre Maori law in the teaching and learning that takes place there. We do engage with settler law to some extent, but primarily from that foundational framework of a Maori legal lens. That might be enough about me for the moment.
Thank you.
Thank you, Carwyn. Tansei Kakia, hello everybody. My name is Darcy Lindberg. As Sarah said, while I was awkwardly standing really high up there, I come from Nihia. My family comes from Nipisi-Kopag, or the Samson Cree Nation, and also the Battleford area in Saskatchewan as well. And my work, I teach at the law school here, as you'll hear a little bit more about in our conversation. And my work with Nihia Wiasa Wawina, or Cree law, is multifold. So the work here, I teach constitutional law, and I think about Nihil Pamatsuin, so Cree way of life. It's supposed to be a conversation. Am I supposed to look at you? No, just kidding. So yes, the question.
Always.
I said there's gonna be I'm gonna make awkward jokes about the conversation style here. That was the first one. I teach Nihil Pamatsuin, so Cree way of life, and thinking about how we think about how that constitutes us as Cree people, flowing towards students thinking about Cree law as they go out. And then another part of my work that is just kind of happenstance as we're going about is I think about our treaties, in particular Treaty 6, and how our laws informed the making of that treaty, and also the interpretation and contestation in that as well. So I'm kind of engaged in that work outside of the school here. Yeah.
And he has to, as a Cree, tell you when he's made a joke.
That was a good one, Heidi.
Thank you. I'll be here all day.
That was one for the niche, eh? That was a good one.
That is how this panel will go, yeah. All right, so. Okay, according to then either Maori or Cree ways of thinking and the intellectual inheritance that comes within that knowledge system, can you guys each speak maybe to like what you think an ethic of care entails and how it informs the work you're doing?
We were joking before, we're gonna have a Cree Maori battle. It's been years in the making out here. I'll go brief, and then I'm sure people want to hear from you more than me. I think about this. I was thinking about this question. So we have this principle that a lot of Nihil folks out in the crowd understand. We talk about it as like mio wichituin, this idea of good support and relations with each other. And it's something that is, I'll talk about it with our students and we'll engage in it. But it's something that is just so uniform in our life that it's there, right? It's I often say it's trite. And so that when I think about like an ethic of care, if we're thinking about ethics of care towards each other, towards our environment, towards our more than human world as we use that language, towards our people we have adversarial relationships with, like the Nish. No, I'm just kidding. We also have within this bond of ethic of Wichituin, right? And it shows up in different ways, like our treaty relationships. We formalize that in a very in our laws. But underneath it, I just look around again to borrow from some of the imagery and symbolism of this land, this sort of thatched, weaved cedar there. We think about these principles as not something we necessarily pull apart as strands, but they're part of our life, right? So I see Rob Clifford here. He talks about not being able to take part of law from our culture, life, those things, and that's the way we think about that. So that ethic of care, we're taught to try to weave it in as much as we can.
Mm-hmm. Yeah, well, in terms of thinking about an ethic of care in a kind of Maori worldview or Maori philosophy, the kind of two concepts that sort of come to mind immediately for me is one, this idea of manaakitanga, and the other is kaitiakitanga. So manaakitanga is is very much an idea about nurturing and caring for others and looking after others. Kaitiakitanga provides it's a similar kind of idea, and you sometimes see them used together. We've come to use kaitiakitanga very much in an environmental context to think about an ethic of stewardship or guardianship in relation to the natural world. Some people tend to, I know some people talk about these ideas and tend to prefer using, in thinking about law, thinking about Maori law, often tend to prefer to use kaitiakitanga because they feel as though that's got the kind of harder legal edge, whereas manaakitanga is this kind of warm, fuzzy idea of taking care and being kind. But I think it's really important to, like, I tend to use manaakitanga as the kind of overarching concept because I think it's important to understand the actual legal obligations that go along with manaakitanga, and that there are consequences if you don't fulfill your obligations to nurture and care for others as well. There's one of our stories that I think about in this context a little bit is from where I'm from, and it's a story involving husband and wife and a child. The wife is she's not really from this world. She's from water people, and so when she engages in this relationship with the husband, and she says to him, if we have a child, you're going to be the one that needs to take care of the kind of all the practical needs of the child, because otherwise I won't be able to return back to my own people. I'll be engaged in this world that you're in, and I want to be able to continue to move back and forth. And so what happens is there's a lot to the story, but to cut a long story short, there's one day some visitors arrive, some chiefs from elsewhere, and the husband is busy welcoming them and engaging with them, and meanwhile the child requires taking care of, and the wife has to step in and do that. And as a consequence, she takes the child and they both go back to her world, and the husband can't see them again. There are a couple of things that I think are important about that. One is this kind of idea of a very strict, it's almost like strict liability, right? There's nothing that can be done once that breach of the duty to take care has happened. The response is kind of immediate and occurs. But the other thing I think is interesting about that story too is that there's that duty of care also, it doesn't necessarily provide you with all the answers, that ethic of care, because the husband is, when these others arrive, the husband is thinking, well, I need to take care of these visitors. But in doing so, of course, he forgets the obligation that he already has to take care of the child. So I think there's a kind of interesting, creates a little interesting tension in there as well when we're thinking about what an ethic of care requires from us.
So I think you've both been talking a bit around this idea of how we think about law through our own stories and traditions, but then what it might mean to have to sometimes extract them out, or how do we deal with that work? If we're not supposed to, as you're referencing the weaving here, extract them out of their context, how is it that you guys, or what are the approaches that you're taking in centering an ethic of care in your own work then when you're engaging Indigenous law in the academy, which often I think tends to ask us to make that law legible through the language of Western concepts and Western practices that do often extrapolate these legal traditions out of context. So, do you want to speak to that a bit?
Yeah.
That challenge or dichotomy at work, yeah.
Who's winning?
I can't even look.
I know.
Carwyn made me even forget to ask a question, so might be the Maori.
I agree.
I was like, wow, listen. Oh, right, my job is to, yeah.
You're pushing this conversation.
I was like the father. I was like, I have this duty to ask a question, except I'm just so intently listening. So sorry, Chris. No.
I mean, I think that's a really important point, is thinking about how to, as Darcy was talking about, to understand these ideas, really in context of a whole system. And, part of the reason why the program that I teach into is a Maori laws and philosophy program is the idea that we need to understand that the law is kind of the ways in which people have come to interpret and apply right ways of behaving from a broader system of a philosophy or values or understanding of the world. And so, that's one of the things that we try and centre in that work. The other piece of it, which I think is kind of important, I'm just thinking about the way in which in our institution, all our students, as well as doing a specialisation, so as well as if you're specialising in Maori laws and philosophy, you do some courses there, but they do some Maori language, but also some courses which encourage them to engage and do research around their own communities and go and talk to their aunties and uncles and go back to their community and make sure they have connection there. And while that's a kind of distinct, that's not the part of the work that we necessarily engage with our students in the Maori laws and philosophy program, it has a real influence on how the students are coming into that work around Maori law. And I think it's a really important aspect of actually seeing these ideas, lived and practiced in community and understanding that they sit within the way in which people live.
Yeah. So I guess I'll just talk a little bit about our program here, because it's different than your situation. So at the University of Victoria, it's a trans-systemic program, so we're engaging with Indigenous legal orders alongside Canada's common law. And so that brings out interesting situations. And when we think about like an ethic of care, it creates, it brings it to the forefront, quite honestly, especially when we're thinking about how we engage in that work. How do we, protect our knowledge systems while having this engagement elsewhere as well. And so when I think about it, just like with students, I try and, I probably fail, but I think about, it's a University of Victoria. I think our word for university in Cree is Kiskano Hamatuin, or that's the way of learning, Kiskano Hamakamik, I believe. But like that word means like this reciprocal relationship on a journey of education, if that makes sense. And a lot of our educators who've obviously come before me have entered into institutions in that sort of way. So I try to embody that, right, in that sort of way. And so it is in a trans-systemic classroom where we all know just the challenges, harms, disruptions, actions, genocides, et cetera, that state law has done to our legal orders, governance orders, et cetera. It can be really difficult to start to engage with our laws alongside, right, and those. And so I feel like there's a special sort of unique care that I find myself trying to take in there. I think about Sarah up there, Heights Quallins, am I saying that correctly? Care. Yeah, Heights Quallin. I knew I was going to do this. I was like, you're so great at trying the Maori words. I was going to butcher this one up. I also just think, again, like what I take from Sarah, trying to have that in the classroom, right? That good feeling where everybody is at one, as like a visitor on this territory, right? That I'm trying to, again, not just center myself, but also to engage in that. And I think it's a common goal for us to think about a Coast Salish world within the law school as well, in those sorts of ways. And so do a lot of work, take a lot of leadership from Sarah and other folks who are in this room. Ian was out teaching our students last week there all sorts of things, right, that I draw in there. So I'll admit I'm not the best visual, like, oh, let's have a community in this classroom. But I do do a lot of things where just in conversations that I'm trying to enact what I think would be an ethic of care of these students coming in here, and not necessarily throwing them into this like really hard way of thinking, especially in their first sort of year.
That's great.
Yeah.
Yeah, I mean, I think both of your responses to that question has me thinking about the ways in which that ethic of care is operating in both directions in terms of considerations of the ethic of care that you need to provide for students, but also then the kind of ethic of care that you're providing for those legal traditions, the knowledge that's informing how these students are thinking about law. So I'm wondering if you have any examples of certain, whether it's like pedagogical choices you make, or here I'm even thinking of other talks I've heard you give, Carwyn, about the ways in which Maori law is operating across the country and having application for both Maori and non-Maori people. Like if there's certain ways then that you try to think about how care is operating when, again, in so many of these contexts, we might be applying one part of the law without those people necessarily being wrapped within that whole system that gives it meaning. That was a half question.
That was a good one. 1 point for the Nash.
I feel like the Cree have 0 points in this game, though.
I was expecting that. I think that I was joking. It's the end of the first month here, and it's Friday, so I'm salty. So I'm like, oh, okay, here we go. Let's talk about. No, I'm just kidding. But there is things like pedagogical choices that I make in there. I sometimes practice what some people will think is like a politics of refusal, and that like where. Again, there is this machinery to a law school where people want to get at the legal knowledge quickly, if I could put it that way, and they want to know the direct analytical way to get there, right? And so, which may work if a lot of folks who are embedded in a Canadian life world, for example, right? You have that foundation to go in there and to read cases and to do that. And so what I find is there is a tendency, and it may be a really natural one for students to do that with other legal orders as well, like Cree law. And so they'll show up and they'll be like, we are, like, give us the straight analytical way to do this as well. And I find myself each year as I learn to do this a little bit better, that I'm going a little bit slower at the start. And so we think about visiting as a really important principle in our lives as Cree people. I kind of look at it as that. I just kind of let the students be like, we're just going to visit materials, right? As strange as that sounds. We're going to visit people. We're going to visit their stories and writing. And then we'll start to think about law as we go down the road. I think that is one there. I'm joking because I'm right in the middle of that with students, and I could sense there's some who love it, right? Just like we're all different personalities. They're like, oh, this is so great. And then there's some who are like, let's get to it, Darcy. I'm not learning anything. What's going on? And they're in that, right? And so it's just a choice there. When I talk about refusal, sometimes it's just like I'm not going to engage. A large part of our laws are, as you know, from your practice in legal ordering, as well as ceremonies, right? And obviously a law school is not a place to explicate all of our ceremonial knowledge and those things as well. And so just acknowledging their importance to our knowledge system, but also just like refusing to enter in there. And again, some people are a little more pushy than others, but it's like you just kind of take that out there. So I mean, I could sense it. Like I had a class yesterday, and I was like, none of my students are here, right? But there's informants of my students who are here. No, but you could sense it. This was actually the tension in the class was that we were taking it slow, right? We were going slow, where folks are really looking for, give us the method that's going to take us right to the center of Cree law, but we're taking our time.
Yeah. One of the things I think is quite important about the way in which the wānanga where I work operates is that we have adopted a set of principles that guides everything that happens in the wānanga, and these are drawn from kind of Maori principles, and you'll find them in lots of Maori spaces, and they include those concepts that I talked about earlier, like manaakitanga, that sense of nurturing and taking care of others. And if we hadn't had the disruption of colonization, we probably wouldn't need to set these out as here are 10 principles and keep referring to them constantly. But because we know we are rebuilding some of that stuff, we need to be really deliberate. And for a while yet, I think we will continue to need to be really deliberate and make sure these are really visible. And we talk with them about with our students in the classroom about how they apply to the work that they're doing, their relationships with each other and with us. We use them in our all our annual reporting processes. So our reports are all organised along those headings. And so that has an impact on the classroom environment for sure. And one of the things that also comes through quite strongly, and I think it's certainly noticed it being sort of distinctive from working in a university, a law school in a university in Wellington, is that the sense of where the authority for or the expertise for this legal system and this knowledge sits. And so, we're, for a start, even in the name of our institution, it's called Te Wānanga o Raukawa. So Raukawa is the iwi or the nation that it's sort of centred around. Wānanga refers to a kind of discussion process, but it comes from an old term. Whare Wānanga used to be the old houses of higher learning. And we've deliberately, I say we, I'm not from that area and I wasn't around when the wānanga was set up, but the wānanga, there was a choice to deliberately leave out the whare part, so that's the building, because to have a sense of recognising actually this isn't a single place where this knowledge is sourced from, and actually reflecting that the students, being really explicit about the fact that the students are all bringing the knowledge from wherever they're coming from. And one of the, I think, really interesting discussions we always have around Māori laws and philosophy is understanding the different stories that people know and the kind of variations in those stories and why there might be variations. And so that leads to really interesting conversations.
Great.
I've heard you talk about, last week, about your institution and just how it's not focused on law. Can you talk a little bit about that? I think that'd be really great for folks to know, right?
So just in terms of...
What else do you do at your
what else do we do?
university?
Right, okay, yeah.
I'm not good at this. That's a -1 for the Cree here.
So the Māori Laws and Philosophy program is one program that's offered at the Wānanga, but there's a range of other programs. The intention is that they're all grounded in Māori knowledge. Actually, we're one of the smaller programs. The bigger programs are certainly Māori language is the biggest, I think, but also we have a social work program, a teacher training program. We have traditional medicine and health promotion, Māori business management and kind of information management programs too. So there's a whole range of different programs. The intention is that they're all grounded in Māori knowledge, and as I mentioned before, no matter what your specialisation is, all students do at least some Māori language and some of these studies with their own communities.
Yeah.
That's great. Can you also then speak to what you see as some of the barriers that arise when engaging with Maori or Cree law in areas or institutions that are interacting with colonial law?
I'll start with one and then give you a break from talking. I mean, the one I see is just kind of what I highlighted. I think there is, there's just a hegemonic position of Canadian law, quite honestly, when we do this. And so there is always a challenge about just people, materials, methods, those things where I was talking with my students yesterday and they're all on their laptops, right? And I said, I could name a case right now and you could go right now as you're sitting here and listen to me. And you could probably figure out what that case is sort of about or be able to regurgitate a little bit because of AI or whatever, right? And those sorts of things. Conversely, some of the things that we share from our legal traditions, you might be able to find some of those online, but it's really, again, just like embedded in people, places, land, etc. To do that. And so it's just quite honestly a lot of work, right? Just like in the work that we're doing in our laws or governance orders, all that kind of work, right? It's there as well. And so I think that is a hidden sort of labor in the work, right? Because Sarah and I talk about this as well. We're always trying to improve our class every year, that we're doing. And then you're like, every year, like, oh, it's going to be so much easier this year. And they're like, oh, it feels so much harder. I see some nodding of heads out there too. Because again, just that sort of groundedness, that sort of responsibility that I feel to our communities, right? To do this right. I think it's difficult where it's like there's that other thing. So I do find that's a challenge. And then the secondary challenge with that is letting students know that without sounding whiny that you're like, my job is hard. No, but just like showing them like, this is why we're making these pedagogical choices, right? Yeah. And doing that, which again, when we have that community, like students are great, they understand. They feel it themselves too when they're coming from nations and communities, but I find that as I would say one of the really larger challenges, I guess, in a academic institution that I'm finding.
Yeah. I mean, one of the things I sort of noticed, well, certainly felt when I was teaching at the law school in Wellington, is the way in which we were dealing with Maori law it always needed to fit within the frame of what an LLB degree looks like, what a law degree looks like, and what the common law would recognise or what statute would recognise, what the courts have said. And so one of the things that's been really refreshing for me is moving into a space where the focus is Maori law, and so not feeling constrained by the kind of settler law framework. One of the things that concerns me a little bit about the sort of increasing incorporation of Maori law into the settler legal system is this kind of, we've talked about before, the kind of taking bits of it out of context, and I think you're already seeing lots of lawyers who are trying to think, oh gee, well, I could use this would advantage my client, rather than thinking about actually whether that's really reflective of Maori law at all. And also just the sense of Maori law and legal processes, it's not just the substantive law that's different, the processes are different. So the kind of idea that you can just take a piece of it and bring it into an adversarial system where actually the process is much more of a discussion based around what the applicable law ought to be, I think also means that the kind of law that comes out of the courts is always going to be a little bit distorted, at least.
Yeah, I mean, and interestingly, I think that happens a lot in any legal tradition, right? Or that it's always a bit extrapolated out of a broader framework. But, I think maybe because of the ways in which we're moving more into these traditions that mirror the state that we're in, that there's just not as big of a body of that for people to turn to, right? Mm-hmm. So then it becomes easy to think, well, this is the exclusive law on this, because we can't demonstrate this like much broader range of ways of thinking about a particular concept or legal practice in the way that the state recognizes yet, right? Which this is where my question comes from. This one, they have no pre-warning of coming. So
we didn't have any warning.
Nothing about anything. This is just so organic. But one of the things I think that really motivated us in putting together this conference around the concept of care was because of the ways in which a focus on politics, on governance and law, has so often been translated through a Western frame that has neglected to think about and center care in it. I'm wondering if you can, think about what might be some of the areas of Maori or Cree law that aren't getting as much attention or focus because of the kind of more Western frames through which we often tend to talk about law and governance. Mm-hmm. Mm-hmm. I always think, I wonder how we would order this if we had just started without thinking about the state at all. Mm-hmm. What would be our category? If it wasn't, if we weren't having to articulate our traditions in response to others trying to impose theirs on us. I think there's a lot of literature that obviously pushes back against concepts like property, but what might be some of the ways, or what might be some of the things we're missing by too often focusing on a kind of reaction to the state when we think about our Indigenous laws?
Yeah, that's a great question. So there's lots, right? There's lots of things. The one that comes to mind right away, I think about citizenship or membership, however the language we're going to use, right? Because not only do we see it reflected in our communities today, that there's the Indian Act here in Canada generates what a certain type of membership is, but when we get into the discussions, even about Cree law, it's funny in class, I'll be talking about Cree law, but also just acknowledging we have so much fluidity from other nations that have influenced us since time immemorial that really has stopped a bit since the Indian Act has started, right? So I think about quite a bit about that. I just often talk about our Ogamawak, our chiefs across that a number of the First Nations are named for. So it might be a Soto, it might be a Cree First Nation, it might be a other nation. If you actually look at their lineage and their history, they're multinational. They're Cree and Sioux. They are, and that was the norm because it was just the idea that being international in that way gave a community strength, just because they're able to gather more knowledge, to understand, to stop wars, to learn more ceremonies, to have treaties, all those sorts of things as well, right? And so, so that's one way that I think if we're starting to think more. I don't even know if membership is the word there as well, but that creates a lot of different complications, but it opens our idea of, one legal order. What does it mean, legal pluralism, if there's a Cree and a Dene families who've always lived close to each other? There's a Cree Dene order there, those things,
Yeah, and I think earlier someone talked about that around how do we think about kinship versus citizenship, or relationality and responsibilities, right? That legal traditions wouldn't then just apply to who we might think of under these Western concepts as citizens, but instead are about a duty of care to one another, right? Mm-hmm. That extends beyond these categories that we sometimes get stuck in because of the state.
Yeah. I mean, that's an area that I see back home as well, particularly coming out of the settlement of historical treaty claims, which require often the writing down of your membership rules for the first time, and so that starts to shape not only how you think of your members for the purpose of the settlement, but for reasons outside of that as well. To lose some of those ideas of how we actually think about our relationships with each other. The other thing it makes me think of is the work that my colleague Ani Mikaere has done around the kind of impact of colonisation on the kind of Maori world, Maori legal world, but particularly for Maori women. She, in her work, she's identified that and that she did a history of her people, and she said it was really easy to identify the male ancestors, but because of part of the process of colonisation and the way in which largely the missionaries had sometimes quite literally erased the female ancestors' names from these records. It was much harder to find those ancestors and their stories. But one of the things she's written about is the way in which, of course, those ancestors were there, and that they held leadership roles across all the kinds of areas that the men did as well. So, political leaders and military leaders and diplomatic leaders. And removing their stories actually has a real impact on how we think about leadership, and particularly think about an ethic of care in leadership, because that part of the story is erased. Yeah.
Yeah, and that makes me think a lot about, I know like so many of our nations are engaged in projects of recovery, right, to bring back these things that have been lost. And then I often think that, we probably were always facing some degree of knowledge loss, depending on what still served us as a people and what was still informing our everyday, but that we had such rich bodies of knowledge because we also had space for so much new knowledge to come forward, right? That in some ways, I think our nations have become, a bit frozen or stuck by the impacts that the state has had that has made it harder for us to recognize those new gifts, new knowledge, new forms of law as they come forward. So just to throw another difficult, unprepared question at you, what might be some of the ethics of care within Maori or Cree law that could also make space for new knowledge to come forward, for new legal traditions, for people to, hear the voices of those who are trying to bring some of those gifts into the present?
So when I talked about the kind of concepts of manaakitanga and kaitiakitanga earlier, these ideas that really do embody an ethic of care, they all sit, of course, in this broader framework, which is really grounded in relationships, and the way in which I've heard some people talk about that understanding of where any individual or indeed anything in the world sits is within a kind of network of relationships, and that network is limitless. And I think that's a really important aspect of it, and particularly when we're thinking about knowledge, because that framework also provides a way of us thinking about a knowledge system of those networks of relationships, and it's important to think of those networks of relationships as being limitless, so that there's a room for constantly expanding that knowledge and growing that knowledge. And the way in which Whatarangi Winiata, who was sort of one of the lead people who established the institution that I work at, he would talk about a kind of knowledge continuum, right? And a kind of recognition that we're building on a whole set of knowledge that's been handed down to us, but our role is to think about what's the piece that we can add that can then be picked up by others that come later. Yeah.
I think you talk about kinship, right? There's like our kinship ordering, like Wagotoen it's always been there, but it's obviously there's fractures that have occurred, and so I think that's one. Like thinking about not only human to human, but our kinship with other species, beings there, and that sort of reopening those flows of knowledge acquisition, so to speak. It's very extractive, I just said, but just that relationship becomes really important as well. And I think there's a way, that we also know that that widening our nets of kinship is hard, and all those complexities of bringing people closer to your fire again is really difficult. So in Canada, we have a lot of nations that are reclaiming the jurisdiction over child welfare that was stolen by the state, and they're finding that's hard, right? In those, and so, but I think that's where there's just that really beauty in your question, and that opportunity to think about this is what law is. It's we have law because it's for these situations and things are really hard, right? And so I think just going headlong into those situations that are really difficult for our nations to do that. I think we'll, because we're going to seek answers for these hard questions that the Canadian state has kind of monopolized, right, for a long time. And with that, I was just thinking about just like what we'll do also, and we're doing it, but just the ability to critique our own laws, right? I think will be really important, or our own governance orders. Because if we're like, I don't know, it's Friday, I have bad metaphors, so I'm probably not going to use the one as like, but it's like I think we're just afraid to open the blinds to, non-Indigenous people, because like it's messy, right? And so sometimes we try to hide our conflicts and there, especially I think about even in our school, but it's like that is actually where our governance, law, constitutions, whatever we want to call it, are sharpened, is when we are in deep conflict with each other, right? And so I think that is like, those are part and parcel. Let's have more kin again, and let's fight more, I guess is what I'd say.
I was like, that is the right message for the Friday afternoon, I think, yeah. But we have to fight with care.
Yes, with care.
I was like Shanna was saying this morning, right? Go to war respectfully. That, part of that sharpening happens when we can actually do it in ways that we're able to hear each other, to engage with one another, and we're not immediately moving into those kind of protective stances that make it difficult to not only engage in conversation, but to actually grow from that. Right?
Yeah. Well, and I think to engage and contest and critique in a way which is consistent with the legal order itself, right? You don't need to do violence to the legal order to make it change. There are mechanisms within it that can make sure that it's expressing the principles and values that we want it to express. And so, exploring those ways of doing it and using the critiques and processes that already exist there.
Yeah, and I mean, I know we've all been invoking John Barrows like he's in the room. I love this. But it does remind me of this time where I was like really worried about some work I had to do with Anishinaabe law, and he was just like, I think our traditions are stronger than you. And I was like, oh, right. Like, it was just this powerful reminder of like, we don't have to always be so scared to work with our knowledge systems, with our laws and our governance, because they are strong and they can survive and in many ways thrive through that engagement, right? That, maybe we've sometimes been more gentle than we need to be with, or we've treated our own laws and teachings as though they have to be handled with a certain kind of gentleness, as though that's the same as care. Yeah. And sometimes care involves the fighting that you speak of, right? So, yeah. So we just have probably time for 2 questions. If there's any burning questions in the audience, I can bring a mic. Sarah will bring the mic around. We have about 7 minutes. Questions?
Yeah. So I am curious about what it means then to invite. I mean, right, if perhaps one of the brave things we do is to open the curtains and maybe the window to, invite others in. What does that look like, right? I mean, I'm thinking about this in the context of your university, where it's like centering Maori law, and then for non-Maori working in that space, what does it oblige us as a non-Maori? I'm saying us to do, right, in relation with that, in the classroom where our students come from all over. What does it oblige them to do, us to do as their teachers, co-learners? I was just thinking about that, like, level of relationality.
Yeah. Well, so one of the things, at the institution that I work at, and so in our Maori laws and philosophy program, we have predominantly Maori students. There are some non-Maori students in the class. But it is a safe space to be engaging with that kind of critique, and I think because of the power asymmetry in the state legal system, and because of the history of colonisation, I do think we still need to be really careful about how we create those safe spaces and how we do, when others do come into that space, how we talk with them about the fact that they're being invited into this space too. Yeah.
Yeah. Hoku, did you say you're Maori? That means you're winning. Oh yeah, I see. Okay. I take this exactly right. I was like, what a bad metaphor, but we're going with it. It's not throw the curtains open, but in situations they're there, right? We have as observers. I think one is just prepping folks, and so it could be professors, because I still do think we need preparation as well to handle the public nature of sometimes this happens, right? And more importantly for students, right? It's not to like throwing into a debate whether, again, I'm going to say whether Cree law or Canadian law handles this situation better. That's kind of like that danger I sense that you're talking about, but more so just being like, we can build upon our knowledges to the point where we actually ask this question of what to do with Cree law or Anishinaabe law there, where we might have differing views amongst Cree people or Anishinaabe people as well. I think it's like those baby steps towards that, and then, yeah.
Yeah, and this makes me think a lot about, Butch and Brianna's discussion yesterday, where Brianna was talking about, that they would tell her to just like listen and watch and pay attention, right? That it doesn't mean you never get to ask questions or that you never get to bring forward critique, but that one might want to learn a bit before engaging in that practice, right? And so sometimes I think what happens when we open the blinds within university spaces is people try to provide answers for situations they haven't had enough time to like observe and learn, and so this is where I think too our legal traditions can help inform how we think about the fact that, like, while we may all have value, we may all have gifts, we all have many things to contribute, that isn't always all at the same time. Yeah. Right? Or in the same like spaces. Yeah. So
I felt like I was one of your students there. It's like,
I know, right? Like,
I just got told to be. No, I'm just kidding.
That's how we talk to the Cree. No, just kidding.
I just want to acknowledge a lot of the time it's not us holding those curtains, right? In these institutions, just want to say it's not always agency that we have in this, right? Yeah. So.
Right. And so I think. Do you want to do one more?
Is there one more question?
Yeah.
I guess talked about distortions and how Indigenous laws might be distorted by colonial courts. I was sort of curious about that and love to elaborate a little bit and just talk about how the process or the Indigenous law, there's that tension there. Can you elaborate maybe an example or two from each?
Yeah, I mean, in the Canadian context, there's lots of examples. I kind of think about it. Well, yesterday I was talking to my students about this. There's like this hourglass effect of like, here's our life worlds. They're up here, and what occurs in the Canadian legal process, like litigation specifically, is that there's a narrowing that occurs, and at that point, courts and lawyers are really looking for the best bits of our legal orders that are going to make it through that hourglass, right? And so it's a challenge, right? And so, for example, we had a case in Maskwacis about 15 years ago where we had numerous of our old ones gave testimony on our oral histories, including treaty and land. and because it didn't fit within the court's view of like what was credible testimony, what they could put weight on, they really just dismissed a lot of our really valued knowledge holders and oral history keepers out there, and then what got through was just like Crown records that were written, sort of thing. So that's a very common thing. There's some examples where that changes. Heidi did a report in this Restool case, which was really positive in the trial decision, where Heidi was using some work from Anishinaabe law, that the judge was prepped to receive that and accepted that evidence. And we're going to talk about John Burroughs again.
Oh my goodness.
One of the secrets of that is that judge actually went to the Anishinaabe law camps that Heidi and John and that a lot of folks go do as well, right? And so it's really changing the minds of these people who are making these decisions to open that up, or a different process. I often talk about like a commission of inquiry would be more better, like where you're just stopping this trial and we're learning all the things we can about like this law and governance order, so that courts can take it in, right? Yeah. So that's the Canadian context in a brief nutshell.
Yeah. And I think just to give a couple of quick examples of distortions in New Zealand context. So there's a lot around kind of relationships to land and land rights and the way the courts have interpreted those. So a couple of quick examples there is, first of all, the courts from the 1860s, when they're identifying who holds the kind of customary interest in the land, they would place a lot of emphasis on kind of conquest, on taking land by force, right? Even though that, in a Maori worldview, provides kind of very unstable rights to the land, but the courts say, well, this is a really strong form of title. Or thinking about the ways in which people succeed to land, where the courts, looked at what was happening in Maori communities and said, well, all the children are able to succeed to this land, and so they should all get equal shares. And so, yes, all the children are able to succeed, but actually, as well as being a descendant, there's your connection and relationship and participation in the land that also determines what your rights to that land are. So again, that's another kind of distortion.
Yeah, and I think, just to wrap up this panel, that, whether it's opening those blinds a bit or how we address the distortion, thinking back to that Restool case, like in a lot of ways, while perhaps the report or the judge's participation in a law camp helped set the stage for her to take up Indigenous law differently, they also had a sacred fire going the entire time. Right, that they were also, like those communities were drawing on Indigenous laws within the form and practice in which our communities have always been drawing on those laws. And so in some ways that enabled the fire and the law, like so many aspects of our own legal traditions that as humans we can't always, grasp and touch upon, to do some of that work too, because for sure, a lot of people, I think, in that case, thought that that judge had been moved specifically because every morning she was also offering tobacco to that fire, right? That it too was providing all this guidance and direction. So yeah, just as we think about the ethic of care, connecting back to some of the earlier panels that we've been hearing about responsibilities to all those relations that we're in. So grateful to be able to sit with both of you and to be able to learn from you, as I always do. It's such a pleasure to always get to hear from you, and it's always a great joy to tease Darcy as much. So with that, please join me in expressing gratitude to our panelists.
Kia Kiiwetinepinesiik